May it please the court, my name is Sofina Boychenko. Along with my co-counsel, Jim Yong Kang, today we will be representing the respondent, the University of North Carolina, in today's case.
The use of race-based affirmative action in college admissions is constitutional.
UNC's affirmative action policy is constitutional under the precedent this court established in Greta. This court's ruling on Greta set a precedent that UNC's admissions policy dutifully applied. The court's opinion within Greta established that a university is required to satisfy strict scrutiny, and to do so, they have to show a fair admissions policy which does not impose a racial quota nor use the race of applicants in a mechanical, predetermined way. Additionally, a school may not use race as a predominant factor in the school's admissions process because it would give applicants who belong to certain minority groups a significantly greater chance of admission than students with similar credentials from disfavored racial groups. Instead, the university's use of race must remain flexible enough to ensure that each applicant is evaluated as an individual and not in a way that makes an applicant's race or ethnicity the defining feature of his or her application. UNC incorporated these standards within the admissions policy and defined diversity broadly, recognizing that no person is one-dimensional and no two people are the same in every respect. They afforded each candidate a comprehensive, holistic, and individualized review. As one long-time member of the admissions office testified, applicants are not just the test score, not just a GPA, not just an essay. They're a whole person. By applying all these standards and evaluating each student equally, UNC admissions policy has been extensively tailored to serve a compelling governmental interest. UNC shows a compelling governmental interest in pursuing the benefits of diversity in education. UNC has made it their mission to serve as a fair center for research, scholarship, and creativity to teach a diverse community of students to become the next generation of leaders. The university embodied the nation's highest ideals by defining diversity broadly, recognizing that no one person is one-dimensional and no two people are the same in every respect. In accordance with the 5 decades of precedent, UNC's admissions policy has been narrowly tailored to achieve educational benefits at the university. This court has consistently affirmed that the interest of diversity is compelling in the context of a university's admissions program. The holding in Barkey reflects the belief that the Equal Protections Clause does not prohibit the law school's narrowly tailored use of race in admissions decisions to further a compelling interest in obtaining the educational benefit that flows from a diverse student body. Because no two people are the same, it is important to factor race as a means of diversifying a campus. It is important for the government to have a compelling governmental interest in the education of students, and considering race as one of the factors out of many other factors is an essential way to improve education at the UNC campus.
The university has a flexible admission program where the use of race is narrowly tailored. Previous precedent cases allow the uses of race in admissions. In 1978, the Supreme Court for the first time addressed Regents of the University of California v. Bakke over affirmative action. The UC Medical School had an application program where 16 out of 100 spots were reserved for minority students, which the court deemed was a quota and unconstitutional. The court specified that while a quota was unconstitutional, the use of race as a criterion in admissions decisions in higher education was constitutionally permissible. Regents of the University of California v. Bakke. The ruling in Bakke set the principle that quotas are unconstitutional, but the use of race as one of many factors is permissible. This precedent is used in the case Gerda v. Bollinger, where the Michigan Law School's admission program that put substantial weight on the applicant's race was deemed constitutional. The Michigan University used race similarly to UNC and used race alongside many other factors in an individualized review of each applicant. It is evident that the use of race in admissions has already been established and deemed constitutional when the use of race is narrowly tailored. The university used race as a sub-factor and not as a predominant factor. The university does not use race as a predominant factor. The race is considered as one of the dozens of factors. The UNC's admission program has the students fill out a common application alongside an essay, 2 short answer prompts, and their test scores. In the application, race is one of more than 40 criteria that admission readers consider. The admission program uses race in a way where it does not largely impact the applications. If a student that applies is a race of a minority group, it does not mean that the student is guaranteed to be accepted. Applicants are not required to say their race and are not penalized if they choose not to. The university performs a thorough holistic review of each applicant regardless of their race. The court in Bakke reiterated that the university may consider race as only a plus factor and must be flexible enough to consider all pertinent elements of diversity. The way UNC uses race is very different from the way that the universities use race in Graz or Bakke. In Graz, the university awarded an automatic 20 points to minority races, which the court found the automatic awarding of 20 points made the factor or race decisive for virtually every minimally qualified underrepresented minority candidate. It is also different from Bakke, where the university set a quota system that was deemed unconstitutional. UNC doesn't have a quota system or an automatic advantage given to minority races and does not make race the defining factor in the applicant. The university has sought out race-neutral alternatives. The court in Grutter stated that narrow tailoring does not require serious, good faith consideration of potential workable options. For the use of race in the admissions program to be narrowly tailored, the university must have considered race-neutral alternatives and show that they do not promote the goals of educational benefits as well as race-conscious strategies. That doesn't require the university to try every conceivable race-neutral alternative. There is sufficient evidence that the UNC has engaged in good faith consideration of race-neutral alternatives over several years. In 2004, the university worked with legal experts and college administrators to learn about other schools' race-neutral alternatives. In 2012, Mr. Farmer and Ms. Kretschmar evaluated a race-neutral alternative that was implemented at the University of Texas. It demonstrated that while it would increase the underrepresented minority groups by roughly 1%, every other academic indicator would have declined. In 2013, Mr. Farmer conveyed a race-neutral alternative working group of faculty and staff that explored 5 race-neutral alternatives that all demonstrated a decline in racial diversity and academic quality. In 2006, UNC convened the Committee on Race-Neutral Strategies, which still operates today, that explores the race-neutral alternatives. Over the course of several years, UNC has demonstrated a good faith consideration of race-neutral alternatives. All of the race-neutral alternatives proposed by the SFFA do not promote the educational benefits of diversity, as well as the race admissions do and are unrealistic. The models proffered by the Students for Fair Admissions had the university choosing between a reputation for excellence and an effort to prove educational opportunities to all racial groups, which the precedent from Grutter says that the university should not have to choose between those two choices. In 2015, the New York Times researched the effects of the banning of affirmative action in the states. The research showed that in nearly every state, the minority population rose, but the amount of minorities that got enrolled decreased after the ban on affirmative action. There are simply no race-neutral alternatives that can replicate the educational benefits that race-based admissions produce. The university has put serious effort to seek a race-neutral alternative and to try to achieve a race-neutral alternative that is workable in the 25-year time set in Grutter.
In conclusion, the court should affirm the lower court's decision.
Does the Equal Protection Clause of the 14th Amendment prohibit race-conscious affirmative action?
No, the Equal Protection Clause refers to the idea that a governmental body may not deny people equal protection of its governing laws. The governing body state must treat an individual in the same manner as others in similar conditions and circumstances. If the university can prove that there is a compelling interest, which UNC has, then race-conscious affirmative action is allowed.
How does legislation enacted by Congress in the 1860s and 1870s affect your answer to number 1?
In the 1870s, the Congress passed the Civil Rights Act, which gave all races equal rights. And this is similar to affirmative action in that it allows minority race groups to have a chance to be enrolled into a university.
Let's assume that the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument still work more than 150 years later in a very different society?
If the assumption is whether the race-conscious legislation is constitutional more than 150 years later, it would be just as relevant or even more relevant, as there are still underrepresented minority groups that could still benefit from race-conscious legislation, and the argument still works 150 years in the future.
Let's assume that the framers of the 14th Amendment thought that people of African descent deserve certain race-conscious privileges due to the unique context of slavery. Would the framers have argued that members of other races, such as Hispanics, Asians, and Native Americans, could receive similar privileges?
If the other races need certain race-conscious privileges, like the black people did, then the framers would probably support similar privileges for them. The race solely is not a deciding factor in the race-conscious privileges to the rights, so the rights would apply to other races as well, regardless of their race. The historical context of a case, which in this case, the context of slavery, does not determine whether they get certain race-conscious privileges or not.
What would the framers of the 14th Amendment have thought about affirmative action policies that benefit people on the basis of sexual orientation or gender identity?
Due to the uneven amount of women and men in certain jobs, the framers may have supported affirmative action policies so certain jobs can have a decent amount of both genders. However, at the time, there was no such obvious moments of gender identity and sexual orientation crises.
Does Brown v. Board of Education prohibit race-conscious affirmative action? In your answer, please address Bakke and Grutter.
Yes, in the case of Brown v. Board of Education, the court ruled that the Constitution prohibits states from segregating public schools students on the basis of race. Chief Justice Earl Warren delivered the opinion of the court, which held that separate but equal facilities are inherently unequal and violate the protections of the Equal Protections Clause of the 14th Amendment. In comparison, Bakke had no single majority opinion, with 4 of the justices holding that the use of race as a criterion in admissions decisions in higher education was constitutionally permissible. Furthermore, the case in Grutter held that the Equal Protections Clause does not prohibit the law school's narrowly tailored use of race in admissions decisions to further a compelling interest in obtaining the educational benefits that flow from a diverse student body. Similar to the case at hand, the compelling interest of the government is very similar to that of Grutter, which held that the use of race in admissions was allowed.
In 2003, Grutter observed that 25 years after this case, the use of racial preferences will no longer be necessary to further the interest approved today. Will there ever be a point in time in which racial preferences are no longer needed? If not, should the court allow racial preferences to go on forever?
Racial preference may still be needed and may exist in the future, only for the right reasons, such as the case at bar. Racial preference is needed in a college environment because education benefits from diversity.
Should Grutter v. Bollinger be overruled? Please address the Supreme Court's recent discussion of stare decisis and Dobbs v. Jackson Women's Health Organization.
No, Grutter should not be overruled, as it sets the foundation of affirmative action which is still needed to this day. Dobbs v. Jackson set principles to determine the use of stare decisis in precedent cases. The 5 factors that should be considered in deciding whether a precedent should be overruled are 1. The court reviews the standard that the court's cases have used to determine whether the 14th Amendment's reference to liberty protects a particular right. The Equal Protections Clause of the 14th Amendment allows the use of race-based admissions. The Constitution makes no express reference to not using affirmative action, but several constitutional provisions have been offered as potential homes for an implicit constitutional right. Next, the court examines whether the right to use race in admissions is rooted in the nation's history and tradition, and whether it is an essential component of ordered liberty. Finally, the court considers whether a right to use affirmative action is a part of a broader entrenched right that is supported by other precedents. The stare decisis from Dobbs v. Jackson does not show that Grutter should be overruled.
If the court declines to overrule Grutter, can the plaintiffs prevail?
No, the plaintiffs can't prevail. The plaintiff's case rests on the idea that Grutter is invalid. If Grutter is not overruled, as it should not be, they cannot prevail.
If the court overrules Grutter, will the military have difficulty recruiting a diverse armed service?
Yes, without affirmative action, military will have a hard time creating a diverse armed service, which is important to the government. To conclude, students for fair admissions versus the University of North Carolina, UNC's affirmative action policy does pass strict scrutiny and maintains a compelling governmental interest.
The court's ruling on Grutter set a precedent which UNC's admissions policy dutifully applied.
UNC does show a compelling governmental interest to pursue the benefits of diversity in education.
For a second point, the university has a flexible admission program where the use of race is narrowly tailored.
Previous precedent cases allow the use of race in admissions.
The university used race as a sub-factor and not as a predominant factor.
The university has sought out race-neutral alternatives.